Before 2014, the UK was only able to tax gaming companies who had a presence in the UK. Gibraltar had its own regime, which meant the jurisdiction kept the profits of all taxation here. But then the UK introduced the point of consumption tax, meaning every time a consumer in the UK places a bet, it is taxed there. The Gibraltar Betting and Gaming Association challenged this new regime before the High Court of England and Wales, arguing it was contrary to the EU's principle of the freedom to provide services. But Revenue and Customs, the defendant in the case, argued that the provision of services between the UK and Gibraltar is not a matter for EU law, because they are the same member state. So this argument was referred to the European Court of Justice. The question before this court was, for the purposes of the provision of services, should Gibraltar and the UK be treated as a single member state or two different states? The court has ruled that, as far as the provision of services between the UK and Gibraltar is concerned, they should be treated as a single member state. It does recognize that Gibraltar isn't part of the UK, but believes that for the purpose of applying the four freedoms of the EU, this shouldn't be a factor. The court says its conclusion cannot be understood as undermining the separate and distinct status of Gibraltar. However, in effect, the judgment means the UK is free to impose its point of consumption tax on Gibraltar-based betting companies.